We're ready. We're gonna start. Yeah. Okay. Hey guys, we're gonna get started. Good morning, everyone. Guys, we're gonna change this up just a bit to get started this morning. We're gonna ask a couple of things. First of all, yesterday was incredibly beneficial to the training staff. We were able to take a lot of good notes based on a lot of the feedback that we received during the training and a little bit afterwards. What I'm gonna ask is this, that both nations are willing to share with us the experience and the knowledge of their time on the job, because this should be a mutually beneficial experience for all of us. So we're going to require interaction this morning. This afternoon, we're going to have scenarios that's going to inspire, not just inspire, but require that we engage in kind of scenarios in terms of presentations. Also, we just want to make sure that Barbados understands we weren't excluding you from the scenario-based training exercise. We just wanted to ensure that the technical equipment supported our endeavor. So we will give you roles within this construct to allow for interaction from you as well. But I want to ask here if there's anything that anyone in either nation considered yesterday and wants to share based on the training that you received. And I'm going to ask for a lot of energy today, guys, so we'll be pausing until we get some answers. Barbados, can I trouble you guys to raise your hands if you can hear me? Shy, I'm not sure that Barbados can hear me.
Good morning, Dominic. Can you hear us?
Yes, we have you now loud and clear. Welcome.
If you can, we're not hearing you. If you can hear us, wave your hand.
You say? Can you hear me now?
Yes, but we're not hearing you. So we have a technical challenge on our end. We try to get it sorted out.
All right, guys, we're going to do a quick recap of yesterday. We just want to make sure that we went over a few of the things. So the whole purpose for this training was because we received information that you guys were operating in what some of your officials required or referred to as a backlog. We want to talk about working through some efficiencies that will ensure a better response to those backlogs. We talked yesterday about the importance of report writing and memorializing things in a report based on certain constructs. We talked about checklists and timelines. One of the things that I want to really touch on is the fact that when you have a checklist, not only is it important that a structure is followed, right? That these items must then be contained within the file, but that they should be sequential. So that's to say that whatever your form of a preliminary report, the very first report produced by the very first responding official or officer, that report should then have its place, a proper place in a sequential order. Then likewise, all the supporting evidence that you collect should have. So that's to say, if you have that original report and then for some reason a summary or an extension of that report comes into bear, like a witness statement from the scene, should have its place in that order. Then also, if there's physical evidence, like tangible evidence that was from an item inventory that helped facilitate the crime, let's say a knife, right? So then that item and all associated inventories based on that, like picture. So if there's a picture of the knife, likewise, that would have its place. Anything. So what we're looking to do is, again, even with the file, just at a glance, that file should be telling a sequential story. So it's not just that we have a checklist of items, but we have a checklist of sequences. And that then, again, you would look at that and you'd say, wait a minute, a step is missing. What that process does is it ensures a lot of self-reporting and self-checking. So you will self-manage. Everyone who possesses that file will be, in essence, self-managing that file and that process. And then I want to talk about chain of custody just a little bit. We touched on that yesterday, but so I talked about what you guys may have, but what I want to hear today is I'm interested in knowing from both countries what process you guys embark upon. Let's stick with the scenario of a knife. So let's say that an event occurred where a person was wounded with a knife and ultimately arrested, and the knife was left at the scene. How that item is obviously collected, but what is your process of processing that item? Like, what is your inventorying process? Certainly you don't leave it there on the street. But no, they're on mute. Barbados, can you hear me? Shy, is Barbados unable to hear us?
Barbados is hearing. They simply need to unmute. Let me just verify. Barbados, can you please unmute? Barbados, if you're hearing, can you please unmute?
Barbados,
raise your hand if you're hearing. There we go.
Barbados, we are hoping for a response from you guys about evidence collection, how you would inventory a knife left at the scene or found discovered at the scene of a crime. Barbados, are you able to hear us? Barbados, if you can hear us, please raise your hands.
They can hear us, but they shake their hands. But you're not hearing anything.
You said they cannot hear? Okay.
You can see Verwalter in the front of the screen addressing.
Now they're muted again.
Yes.
While we wait for them to work through this difficulty, because they put them on mute again, can someone here please tell me how you guys would collect that item?
Come on, guys.
Gentlemen, this is just going to make for a long afternoon if we don't engage.
Good morning, I'm Innocent Toussaint.
Good morning.
During my time of investigation, it's quite a while anyhow, what we'll do is we will make a note of the exact area that the item was seen, and we will make a note before we collect it. After it is collected, well, during my time, there was not as many photographers, but now we will photograph it before we move it. And then you make the necessary notes, and then you inscribe your initials onto it, and you secure it, take it to the office, and then during the investigations, the different persons that see the knife, identify the knife, we'll ask them to make the small inscription to initial it for further identification.
Sure.
And then if there is forensic, for forensic purposes, and then it is stored away in the exhibit room with a proper labeling, so it can be easily be retrieved for court purposes.
So two things. First of all, thank you, sir, for explaining that. The reason for the rationale for that question, guys, is to show you something. What that gentleman just explained is exactly how we process items in the U.S. And so it's important to understand that the process, the system, the sequences, ensuring that every person who now comes into contact with an item of evidence must memorialize themselves on a report to ensure that that proper chain of custody is unbroken, right? So that's a uniform practice, throughout. So I appreciate you sharing that with us. We just want to make sure that we're touching on things that you guys are interested in. But I do have this question. Does anybody have a question here? So let me ask this. And what I'm going to ask is this. I can clearly see with the insignia, and I'm well aware of your chain of command and the hierarchical system that exists in this room. With that being said, I'm just going to ask if those in power would allow for a little bit of honest dialogue. And I would never ask a question that would speak against either government or either structure of organization. So we're clear on that. But I'm just simply asking this question because we're literally fact finders, right? Good morning, sir. But what I'd like to know is this. If in essence, you guys individually, you men and women, could extend to us a recommendation. It could be a mild recommendation here, but if you could extend to us an honest answer to something that you'd like to see responded to, that would certainly be welcome. Is that a proper way to state that? So can I have any takers, any bold, brave individuals from either country? Yes, sir. Next time, somebody without so much rank. Yes, sir. Go ahead, boss.
My name is Clyde Charles. I'm Inspector of Police in charge of the St. Joseph area. I was just transferred there about 4 or 5 days ago. I was in the South Grand Bay area. My concern is, and I would like action be taken, especially in the matters concerning to little children, young girls, when they are being molested. It is unfair to that child for me as a prosecutor to be there trying to get rid of from her what a man like myself did to her. I have recommended that they should train a lady prosecutor to deal with those matters. My reason for that is that child will be more open to speak to the lady than to the man, knowing what the man has done to her and another man is trying to get it out. I don't know if you could use your office and relay that somewhere and something be done. Right. Because I don't like it. I have to do it, I do it. But I don't like it, it's not nice. And I need action to be taken. Thank you.
So, first of all, boss, thank you very much for that response. I'll say this, our special victims unit in my town, we literally have both male and female investigators. In fact, on that type of a call for service, we're required to dispatch a female investigator. And then likewise through the court system, all the way through the process, there's a woman attached. That will certainly be a recommendation that we give high priority to on our report. And thank you for pointing that out. See, and what's important is we're able to share with you what we have. And again, our system isn't perfect, but if there are practices that are in place right now, in my town, I can certainly extend the courtesy of recommendations, strong recommendations to your countries. And just so everyone understands, this literally has changed things. We've seen changes in these times that we've been here. And I'm not going to overpromise, but certainly a response mechanism starts today, just from you mentioning that. So I certainly appreciate that because I was unaware.
If I may add to that, I think one of the first things that I did when I was to recognize the need for victim support and victim unit.
At the bottom.
And suggested that by way of recommendation, is this one on?
Yes, we can hear.
However, it's something for us in our system that is, maybe that's too strong a word, but it's a bit novel. And so I remember my ministry saying to me, well, we can't give you any staff or any support for that, but you can go ahead. But of course, you need support for you to have a victims unit. And in fact, victims' rights are being touted a lot. A lot of countries have passed legislation in relation to victims' rights. And if I'm listening to what is happening in some states in America, they're asking for amendment for victims. And as part of the election, the midterm elections going on.
That is correct.
A lot of states are lobbying for victims' rights. In fact, it really affects matters, the prosecution of matter, when your victim rights is abrogated and not highlighted. Not only defendants have rights. Yes, they have rights. They're rights by the Constitution, but victims also have rights which must be taken on board. And of course, what Mr. Charles says is one area of concern. The corollary to that is that boys are also abused. We have young men who are abused sexually, and I don't know if it's a woman who they'll talk to, who they'll open up to. Also, so it's not only about the girls, it's also about the boys. So if you add your voice to it, I am sure that it would be something that probably people would start thinking about.
So before I let my colleague take over, I just want to say something. You brought up a great point.
Yeah.
Whenever a new big legislation is introduced, right, in any municipality, the time is right then for all like municipalities to then start their roar, right? Because once that process begins, then it sheds light that the need is global, that it's not just regional. So it is excellent that you bring that point up, and it just goes to show you, if it's changing now where we're from, then that momentum can continue and extend to you guys. And we will certainly make that strong recommendation.
Yes, and some of these songs that I'm hearing, if I may, some of these songs that I'm hearing now is that some people are even saying, well, it's a state case, but it's not exactly the state case. It's a victim case. I don't know how we're going to buy into that, because it's a new voice that I'm hearing, but it may have some credibility because the victims are also affected, and we treat them just like an ordinary witness, like they don't care. They don't even know what's happening. They don't understand what's happening, why their case adjourned, etc. So it's an area that's going to help with prosecution if we give.
If I may, just to follow up, and I did not address this yesterday, but if you can turn to tab 13, I talked about what our victim witness advocate does in our prosecutor's office, and how that person pretty much acts as a liaison between our office and certain resources that are available to that victim or witnesses in a matter. But if you could turn, I'll first start with tab 13. This is an example of a victim advocate checklist. It starts out with the responsibilities of the victim advocate. There's a section in there for law enforcement responsibilities. It's almost like a checklist of something that the officer should do when it comes in contact with a virtual complainant or identifiable victim in a case. On the second page, it discusses the prosecutor's responsibilities. And it's just a checklist to make sure that, and most of our rights are codified. And so this is just a checklist for the prosecutors to make sure that we've dotted our I's and, we've made sure that we've followed the statute that's in place, that we haven't violated any statutes. Tab 14 is an example of our federal victim rights laws. We have state victim right laws and we have federal victim rights laws. And the first, if you look under subsection A, sections 1 through 8, we have to, as a prosecutor, abide section A 1 through 8. That's on the first page at the top. We have to abide by sections 1 through 8 as a prosecutor, and if we do not abide by those rules, we could be sanctioned or we could lose our job if we do not follow these rules. So our victim witness advocate who's embedded in our office makes sure that we follow these rules. She's the person in the office that makes sure that the victim is notified of the court appearances. We have paperwork that a victim fills out to make sure that if a person is convicted, that when punishment is imposed, that restitution is also made a part of that sentence. We have to provide victims with notifications of the different adjournment dates. They have a right to confer with us about the case, not saying that they can tell a prosecutor how to handle the case because that's in our purview, but we should consult with a victim when we're deciding how a case should be disposed of. During sentencing, a victim has a right to allocute at sentencing. They can appear at sentencing in person, and they have an opportunity to appear before the judge and talk about what this process has meant to them or what the crime, how the crime has affected them, whatever they may feel. They can make a suggestion about a sentence. If they don't want to appear in court, they can submit a victim impact statement. And that statement, if the victim wants it read aloud, we as a prosecutor will read the statement out loud. Or if they just want the judge to read it and just take the statement into consideration, we can submit the victim statement to the judge, and the judge will read it without actually reading it out loud in court and take the statement into consideration before imposing a sentence. But again, our victim witness advocate kind of ensures that we abide by those 8 rules so nobody gets in trouble. And the victims know, what their rights are. And in certain situations, if some of these rights, if they miss a hearing, they can petition the judge and say that, that their rights, whichever right was not followed upon, was violated. But again, that's what a victim witness advocate is for, to kind of make sure that we abide by these rules. The victim witness advocate is the person who keeps in contact primarily with the victims in a case, because as prosecutors, again, like I said yesterday, we're not able to sometimes as we would want to because we have other cases on our plate that we have to deal with, and time is of the essence in other matters too. But that victim witness advocate in our office takes on that responsibility. In my federal prosecutor's office, we have 50 attorneys and we have 2 victim witness advocates. And that's just what they do all day, every day. They have pagers, cell phones. When victims need to get in contact with them, they have to be made available to that victim when that victim wants to talk to somebody. The victim witness advocate also, if I have a trial that's in another county, or if the victim, they help make travel arrangements for the victim, make sure the victim's in a hotel and has transportation back and forth, whether it be making an officer going to pick up the victim or not, but we make travel arrangements and hotel arrangements for them also, in addition to making recommendations to different social services for that person. But that's what that victim witness advocate does, as an extension of what the prosecutor is supposed to do. And so I remember last year when I was here, Madam DPP expressed the need, and I will tell you that I've made that recommendation And I know that it's being researched and looked at to provide that training, not only for this country, but for other countries have requested the same support and assistance too. So it's a priority, as it should be. And I understand with the gentleman in the back, it is difficult sometimes for children to, if a male was the alleged perpetrator, to speak to another male. And that victim advocate, it's not just some random person, but it's a special, we have male and female advocates. And it's a special gift with these people and the relationships and the bonds that they build with victims, young and old in certain cases. It really takes a special person, and the lady who I hope that will provide training for you, when you meet her, you understand that she really does have a gift. Any other questions about victim advocacy? Again, I'm making that recommendation, and it's the top priority for this region. Microphone, yeah. It's working.
Good morning again. I'm Cadet. My question is along the lines of witness advocacy. And too often times, we have noticed that the empathy or sympathy, which should be ascribed to the victim, has been shifted to the accused. And that predominantly implants itself into a criminal matter over time. Am I understanding your explanation of the victim advocacy to be bridging that type of gap?
Yeah, well, I will tell you, based on my experience, there will be the victim, and then for the defendant in the matter, the whole church will come out for the defendant and sit in court. And it happens a lot like that. He has the whole congregation there and nobody's there with that victim. The advocate and other social service resources that maybe that victim has used, those people will be there and sit beside that victim too. So she's never, he or she is never alone. They're never alone.
I could add, is that
yeah.
the I'm not a DJ, so I don't remember mics. The jurisprudence is that the court has not, that they work with the old system where it was always defendant's rights, accused rights, and not victim's right. And little and sometimes no attention is paid to the fact that victims have right. And you see it sometimes in the way the prosecution is treated. A defendant, his attorney may come and ask for an adjournment for a spurious reason, and he'll get it. The prosecution might be asking adjournment for a good reason. Maybe the witness is frightened or she's having a bad day, because, you know, when they go through these kinds of trauma with these offenses, sometimes it's not a good day for them, or she may have school exam. And, you know, to try to go and get that adjournment, you wondered if you'll get it. It's like you're pulling teeth. It's like nobody understands. So the way sometimes the prosecution is treated reflects that nobody pays attention to that. Mm-hmm. They think that they treat the prosecution like we can make magic, we're magicians, and everything that, since it comes to us, it must be perfect. And we don't live in a perfect world, and nothing is perfect. So we have as much difficulties. So the thing is that I think we have to get our judges to understand that victims have right, and victims' right must be considered. And some of the way that they do things the old way in the old jurisprudence probably is not what we need to do. So I see that you need overall training, even in that area. So I don't know, Mr. Cadet, if that will change next week or next month. because it's a process. I'm not saying that there are no judges who do not probably have a bit of understanding of that, but really that's not really the jurisprudence. We're just going into a frontier where we have to train them and teach.
It is a sensitivity training too, and we have, if you look and in your time, there are other laws that are put in place that mandate that the court ask certain questions at sentencing. They have to. And you're right, it is some sensitivity. We have some too that are that can be dismissive or flippant about it. Some of the things that we've done to help with, because we know that defense counsel will ask for an adjournment to kind of just wear the victim down, where the victim is just tired and may not want to go forth with the case. And I mentioned this the last time we trained in Barbados too. And actually the magistrate judges that we talked to were in favor of it. If we know that we will ask, most judges would agree to this. We would ask that a witness be put on telephone standby. And so in court, if we were able to, how you did the other morning, you got the arrest, the remands, those quick things out of the way. And if a case was going to be called for, we wouldn't have the victim there sitting there through the quick things, the quick matters. And if the case was going to be for trial that day, we would tell, Your Honor, the witness, if the case is not continued, we can have the witness here in 30 minutes so we can do other matters first. And so most of the judges have been pretty open about getting other quicker matters out of the way, or maybe smaller trials where the witness was just an officer, getting those out of the way. And we would have someone from our office call the victim and say, you need to be here at 11, or have an officer go pick that person up and say, can you get him there at 11? And so we've been able to work it out that way too. So the victim wouldn't lose time at work. They've been open to putting victims on telephone standby and witnesses in a case on standby, and we would have them at a certain time.
I just want to admit, Mrs. Durham, please, so she could tell you a lot about that. A lot of the cases that we do, the sexual offenses type of cases, in fact, we find ourselves not just preparing the case, but preparing the witness. And part of that preparation is psychological preparation. Now we are not trained, but the way we get those witnesses there, if they wouldn't even give evidence. If you do not work with them because of the way they present, and most time we don't recognize psychological trauma. We take it, we deliver it flippantly, or in Dominica we have a favorite word. The child is wicked; she don't want to give the evidence. But the thing is that really is, shows a lack of recognition of what is happening. A lot of the cases that we have won, sexual offenses cases, if we did not work with or counsel who has the case work with the witness, would get nowhere, and that's not really part of our job. But we are forced to do it. Forced to get through.
At trial, when I do have a sensitive or vulnerable victim, and you do have to spend more time with that vulnerable victim. Most of the time, they've never been to court before. They've never testified. So the way that our court, I have them come in and look at a courtroom, sit in the witness stand and start asking them questions just to see. And most of the time, our witness stand is right beside the jury box. And so you can look at me when I'm asking you a question, but the jurors are the finders of fact. You don't have to look at the defendant. Just when you answer the question, look at the jury. So look at me and then look at the jury. It helps a little. You don't have to look at him. Just look at me when I ask the question and then look at the jury and give them your answer, because they're the finders of fact. Microphone. Okay. Okay, Barbados, if you can hear me, just wave your hands. Okay.
Okay, Sergeant Daniel. Okay, observed in cases that victims are normally bullied by lawyers. Actually, I wonder if there is anything that would help. I think the victims advocates or whatever would help very much in that case to prepare them, because as the DPP said, she's not a counselor and she has to do that work. So I believe in that case, I've seen many cases go down the drain because of that.
The victim witness advocate is pretty much a counselor. Like I said, it's if you're able to meet the advocate that we're recommending, you can tell that she has a gift. And most of the advocates do is something very special about them, and they just are magnetic or able to just be sympathetic and sympathize with that person. And it really helps me as a prosecutor, because I don't want to be just, I have so many other things that are on my plate too, and I can't focus like I probably should, but I can't focus until I know something's going to be ready for trial.
If I can butt into is some jurisdictions, like in England, they have developed methods of cross-examination of children and what questions you can ask them. So counsel cannot bully a child in court, cannot ask those kind of rough questions. They have their laws actually for that. So for child victims, you're not going to cross-examine them in the way that that we do, and some of those questions you will not be able to ask them. So that's where we have to go. But you know,
you're not going to re-victimize the victim again on the stand. And you know, I don't know how it works here, but if a defendant comes across like that, it's a turnoff to the jury. That you're treating this,
depends on the kind of jury you have.
Well, yes, it does. But it's normally a turnoff, and Madam DPP is correct that we would object to being argumentative, to being hostile. There are different lines of questioning that we can object to. Yeah.
Well, there are laws in England. You can't badger a child.
Yeah.
And there are certain questions you can't even ask them.
Does anybody have any other questions about victim advocates or advocacy before I turn it back over to Landon? Again, it's a priority, and I'm making that recommendation not only for Dominica, but for other countries as part of this initiative. And Barbados, I'm not sure if you can say, they can't say anything. Oh, okay. Okay, but they can hear me. And I'm making that recommendation to Barbados. And I know that, like I said, the magistrate judges were pretty open to having a witness on telephone standby instead of just sitting there in court and then the case get adjourned for another day. If we know as a prosecutor it's not going to be reached that day for whatever reason, we would have that witness on telephone standby and say, well, it got adjourned, so don't worry about it. Or the defense counsel's available. We're ready for you to come in today. Normally, in those cases where we do have victims, it's not in statute, but it's just some of the courts have their own rules that, you know, if there's a identifiable victim in a case, that defense counsel should notify us earlier if you know that you're not going to be in court or something, so we can let the witness know. Some judges just are like that. You know, they will, if defense counsel comes up and says, I want a continuance for whatever reason, the court will ask, when did you notify the prosecution of this? Because the victim is here and we're ready, you know, and we as prosecutors, we're ready to proceed today, you know. And the judge may deny their motion and may go forward with the case today if the victim is there and we didn't receive earlier notice that they weren't available or not prepared. Okay. Any other questions, comments? All right.
Guys, I wanna talk about the process again. So when you guys obviously take a person into custody, there's a preliminary report. Please walk me through this, someone. when you take a person into lawful custody and then you produce that person into a holding facility, is a report required before that person is housed in containment or confinement? It is. Okay, so just one report? Like, is there just one standard arresting report that's required?
It's a standard report, yes. You make a note in the diary and you put the accused in the cells and then you move from there.
But there's no paper report?
No, no.
To go into custody. So what's the formal process? So if I were on loan to your police department and I was fortunate enough to see an assailant commit a crime and I captured that assailant and I bring him to a police facility and I myself am allowed to be sworn and working here in the capacity of law enforcement, what would be the transaction when I put that person into confinement? What would I have to do?
Well, you probably continue investigations into the matter, and you would ensure that, I mean, the investigators, I shouldn't be answering, but you would continue investigations, take your witness statements, start taking your witness statements. You have 72 hours before you bring him before a court if you're going to charge him. If you're not going to charge him, you have the same 72 hours in which you can release him if your investigations show that there's not enough evidence to file a charge.
Okay. So
that's the initial sort of thing.
So is that the first time that someone questions whether or not I had, in fact, the right and a rightful purpose to be able to bring him into confinement?
The thing is that you arrest on the basis of reasonable suspicion
Correct.
that he has committed an offense. And once you are satisfied that you have a reasonable suspicion that he committed the offense, you can arrest. I mean, if something arises later on, yes, it would be whether you had reasonable suspicion to exercise an arrest. So
understood. Now that's what I reviewed before we came here, and that's what I want to get at. We have to have probable cause, which is a higher standard. But my question is, I guess then, who then measures my reasonable suspicion? So when I bring him in and now he's collected and accepted into confinement, who can question whether or not my suspicion is reasonable?
Supervisor, there's a supervisor.
Okay, so there is a check and balance, but there still is no memorialized report expected at that moment, correct?
Not right then.
Not right in. Okay, and so within 72 hours at some point is when this report comes to life? Okay, so this is what I'm getting at. Because yesterday when I was talking, I had to make sure that I slowed down because my mind was thinking about a different concept, right? I was thinking about cases where there were a lot of different like task force, right? So I wanted to make sure that I was speaking properly. So what I would hope is that you could apply the concepts of that like timeline, and I get that when that matters, but or when it's consistent with those type of crimes. But in terms of a more effective way of hopefully defeating a backlog or inspiring a change in reporting accuracy and completeness, what I would suggest then is, as a recommendation, that preliminarily, even if it's a half sheet, a paragraph, that preliminarily some type of report is necessary, because it does two things. It starts a process in motion, and then it starts a formalized reporting mechanism, because then now everyone must take that one step, so that to the court prosecuting police, they already have a baseline. So there's already a line in the sand or a bookmark that shows. Does that not sound
No.
reasonable?
I was just asking in that preliminary report. I was asking, what do you put in it? Because I don't think you have time at that time to do a full report. But I'm just asking, what are you suggesting is putting that person.
So again, I'm huge on timestamps. So in my opinion, as an investigator, I would stamp a few things. I would memorialize who the person is and so the uniqueness of the incident, all the uniqueness. And so what I mean by unique is I am uniquely me. So all of my identifiers, everything. So if I'm driving a vehicle, my license plate information, any personal credentials I might have on myself, my birthday, right? The day, time, and location where it happened, and that's it. Because if you have those things, I am the guy. I'm the right guy. So as I move along through the process of court and processing, I'm that same person. And if I have a tattoo, this undeniably me. See, so what you're lending your voice to immediately is uniqueness. And then once you do that, then now you interrupt that process, because then I suggest, and again, I understand resources, right? That those officers probably are meant to be right back on patrol. But that the process of them responding, this is what I tell my guys, because trust me, in organized crime, my guys, and I'll just be completely honest, and some people in here probably understand this. Some of these positions that you attain, and certainly where I'm from, you have to really hold on to them. These guys get to walk around in plain clothes and drive the covert vehicles and so forth, and they have all those toys. But in order to stay there, sometimes the expectation may be that there's a volume of activity, okay? So I'll say that without using words like quota and so forth. But the fact of the matter is this, then now they've made an arrest, which is probably a pretty good arrest, because those young folks, like the gentleman I saw in court, the investigators, they're really, really good at what they do, but they're hungry to go back out and do more. But what I challenge them to do is this: the value of the way they process and the value of reporting and the actual case building. That's really that's the most effective way of influencing this justice system. So the number of persons arrested pale in comparison to the high volume of good cases that are defended in court. And that's why the process should begin somewhere, that there should be a formalized methodology that each one adheres to, so that even if the numbers of arrests are diminished, the quality rises overnight. It really happens just that quickly. When we adopt it, and again, keep in mind, these practices don't go so far back in my agency. But once we adopted this, we changed it overnight. We changed the volume. We changed the volume to be a lesser indicator of good policing, and the quality being a higher measurement. And what it did is it poured across even the officers that still patrol in uniform. They started adopting some of the methods, because in court, what they were seeing is we had uniformed police officers that were doing patrol arrests, just responding to radios and dispatch calls. And then we had investigators working in plain clothes that were doing more complex investigations that were based on some type of prolonged investigative strategy, right? But they be side by side in court. And oftentimes we found that the officers that worked in more of a specialized unit, they were getting wins in court because their process was fail-safe. It was sound. So the uniform officers began to mimic the system, and they likewise started to bring better, more quality cases to bear. So it's just that process, but it's just, and that'll be a recommendation, because it's a good practice. And what it really shows is it shows the necessity that an officer, a crime fighter, is also a report writer, right? Because that's important, and it bridges a divide. And it seems like an odd, mix, but it's necessary, because who better to author a report about a crime pattern or criminal behavior than the person who's viewing it on a daily basis? That should be the author, because that's the unique participant, right? So that's something that I really want to make sure that you take away. I want to make sure that this is, and that goes for you too, Barbados, that that this design works regardless of where you apply it. It really does. From the vagrancy arrest of someone on the street, if the process starts off the same way, then success is the only thing that lies in front of you. I can? Yes. Okay, great. And he will do that? Okay. Barbados, I'd like to know the same from you. I'm aware now that the mute is able to be turned off of your computer. And again, I'll say welcome again. Can someone answer for me, if an arrest was made of a citizen for vagrancy, what is the process of taking that person into lawful custody and then depositing them into confinement? Is a physical report required?
Yes.
Thank you. Will someone do me a favor and elaborate on what would be contained in that preliminary report, please?
If the person who's loitering, the person that made the complaint about the loitering will get a statement from them. Along with, you will take that person into custody and go through the process of prosecuting them. Church procedure.
But on the arresting report, on the documentation, what would be housed on the documentation?
Good morning.
Good morning, sir.
Hi. Now, when a person is arrested, the first thing you bring them to the station, you will document their arrival at the station. You'll have the SPO interview that person, and then you'll have the statements from the witnesses, civilian witnesses out there. Record that. The SPO, then the investigators interview the person, tell them about their rights and everything, and then you process them for the court. That's basically the system we have here for that's it on the vagrancy issue.
Okay, sir, what's the next step? When is the drafting of future reports required or embarked upon?
After the person has been processed and sent off to court, the investigator, he writes up his statement of evidence and he prepares his report, like as to how what report was made to him and the process of how the person was brought into custody. He prepares a case file, which then goes up through the chain to the supervisor and then off to the prosecutor.
Sir, I thank you for your very thorough response. It sounds like we're on par here, that all of us process this the same way. What we're really looking for, I haven't found many, is any kind of deficiency that might be causing a stall in the process. And if anyone there in Barbados may speak to an efficiency or response or an antidote to a problem that you're seeing, please vocalize that to us.
No problem. The problem comes when you have defense attorneys. That's the only problem. They stall the process, sometimes for minuscule issues.
And in terms of, you're saying they're stalling the process in terms of a readiness for trial, correct?
Sometimes it would be readiness for them to make their finances bigger.
Understood.
All right.
All right. Thank you, sir. Guys, I want to talk again about, I want to hit one more quick point here before we go on a quick break. Oh, yeah. But yeah, before I do that, I want to talk about this. So guys, does anyone in either nation, do you guys produce on a regular basis after action reports or have briefings after a deployment? You do? Like, are those major deployments or after general arrest procedures? Major? All right. Is anyone willing to admit or not aware of what an after action strategy briefing is? So I'll give you my interpretation from my region. An after action report, we do the reports because we're really report heavy, only because we found that our biggest flaw was that when we had officers go to court, they were then asserting things that were not contained in reports. And they were asserting extraordinary items, right, from some memory bank of theirs. So, and in a lot of instances, it seemed as if these were things that actually happened. So what we started doing is we challenged the system. So we challenged their memory and their behavior by literally making them memorialize it. So what we did is immediately, if you remember the example I gave you yesterday of the NATO mission, immediately upon placing a person into custody and delivering with that person the transaction of handing them over to a detention aide with I'll call it a receipt, really. It's a receipt report. It's the probable cause report that shows that I had lawful justification to arrest this person. Then now, once that transaction is complete for the moment, we then retreat back, the squad, the group of persons involved in the arrest, and we debrief. We talk about immediately what happened during the let's say capture or arrest of this individual. What were the good things and the bad things? It literally lends itself immediately to best practices. It shows us our strengths, and it certainly reveals to us our weaknesses, which in most times are way more valuable than strengths. We all know what we're good at. Very few of us are willing to stand up and admit what we're weak at, but this exposes that, right? And that exposure then lends itself to improving the process. So we do that every single time that we put someone in custody. It's required. Our supervising sergeants literally are meant to talk to the officers who have taken this person into custody and to notate on a log that is required. So independent of any arrest made, you could have a group of 10 officers on the street under 1 or 2 sergeants, and there may be no arrest activity, which would never happen in Chicago. But if it were to be a day that quiet, a sergeant, a supervisor, is still required to turn in a log, a memorialization of all the things that occurred on that day. And in that log, the expectation from me, his supervisor, is that I see that he had an opportunity and took that opportunity and made it, realized it, right, to engage his subordinates in a conversation, an actionable conversation that talks to their processing, right, or their movements. And that redundant system of reporting, it just lends itself to credibility. It really does. So we are paper report heavy where we're from. We literally are. When I talked yesterday about a couple of investigations, one I mentioned was a 2-month-long investigation, and the other one was a 4-month-long investigation. Each one of those investigations would be this thick in reports, no question about it. But what's awesome about it is, just like your books are presented and offered with tabs, it's just, and the expectation is you know exactly where in this reporting mechanism your fruit lies. It's there. It lays where it's meant to be. It's orderly. And this book then becomes a supervisor in and of itself, because anyone who walks up to this and wants to know where we are in the stage of processing this crime or this person or these persons, we literally can look in here and we can supervise ourselves, and we can require then that once this thing is handed over, there's nothing but confidence and calm for those prosecuting, because it's what's required, right? The chain of custody tab. Thank you. It's on tab number 7. If I could ask you guys to flip to tab 7. Oh, it's is it page 7 or tab? It's tab 7. So that's in the book. I'm sorry. Yeah. Okay. So the gentleman in the back gave us a depiction. He started back before cameras were invented, it seems. I'm just teasing him. He said that those were his words. So anyway, his depiction literally is memorialized in this page. I could not have said it better than he presented it. But the need for this sheet here, again, it's a receipt. It gives notice. All of our reports give notice to the court. It reveals 2 things. It reveals that we're organized, and if we made a mistake, it reveals that it was unintentional and that we acted in good faith with good intention, and we hoped to achieve the expectation of the court. That's what our expectation is, and we humbly present this to the court as a good gesture, right, in good policing and high integrity. But it also, more important than that, it's habit forming. These forms, no officer is allowed who engages in the activity of processing a crime scene. No one has the luxury of omitting this form. It's required. It's something that's as attached to that officer as any other weapon in his or her cachet. This thing is required, and then it lends itself again to think about how many cases you've seen yourselves that have been lost because of question of where evidence not only is right now at present, but where it traveled before it got to its rightful place in court as a court exhibit, right? The fact of the matter is, if we could track that systematically, look how many questions we answer. So, and yesterday I heard a couple of people mention this. Well, what if the defense says this, or the defense could whatever? I got to be honest with you. It's been years since I cared. And I'll tell you why. Because when I walk into court, I literally want to say to the defense, without saying it out loud, here you go. You're in for a great fight. Good luck. Because the bottom line is that confidence comes from these reports. Anything that he or she can bring to me, I've already anticipated it. There is a finite number of defenses that you can have against any crime. So if you think about that, what could they allege? What could the defense allege? If we want to play that game, we could do that. And I guarantee if we had a board, I would ask you guys to write it out. The holes they could punch in your case. I guarantee you we wouldn't exceed 50. If I gave you one particular type of crime, you wouldn't exceed 50. So 50 things in a complex case, a case that's important to you, because you really want this case to go its normal course and you want to see justice, right? So 50 things. I would then challenge my small squad to say, okay, come up with the 50 things. In our report processing, I would then say, okay, attack, guys. Attack the things they're going to attack. Did we take pictures or draw pictures? Did we memorialize facts? Did we write reports? Did we interview witnesses? Did we ask the right questions? Did we listen more than we talked? Did we employ any electronic surveillance techniques? Could we have? Did we go back to every place this person did, in essence, or could have traveled? Did we collect trash that was able to be collected, with no expectation of privacy outside of a property line? Was there any trash available? If there was no trash available, did we notate? The only reason we didn't collect this, and the reason for that is because of bills and any other types of notes that people would keep. And I guarantee you, I thought it was not. I said, how was it a promotion if I'm in a trash can looking for bills and letters? But we found so many patterns of behavior and movement by looking at people's records and being able to find hundreds of thousands of dollars of illegal funds through banking networks by the things that people discarded. And we were able to find that and take pictures of them, not bringing dirty garbage to court, but memorializing the fact that these folks housed that. And ledgers. I would have never believed how many humans keep ledgers about their bad actions. They literally keep diaries. And the more sophisticated the criminal, the more they write. And it's amazing because it's just virtually impossible to keep a mental record of the things that you must do next. So you'll find ledgers constantly, and they're in all forms. But if you go to court with this type of a process and a ledger and a picture of a dope movie, these types of things, the court is saying that's a thorough investigator. And what happens, we talked about habit forming. The judges, when they see you come in, my proudest day in court happened about 10 years ago. I walked into the courtroom late, and the defense attorney was standing and he was giving some type of a lecture to the judge, it seemed. He's being very demonstrative in his actions, and I couldn't hear what he was saying. And when I walked up, the judge looked over as if he were disappointed that someone interrupted his court while it was in progress, and the defense attorney turned around. When he turned around and saw me walking in, he turned and walked over to the prosecutor. They walked up to the judge, and he asked for a conference. He asked for a plea. I know you guys don't do that here, but what that meant was he was aware of how we process cases. He told his guy that he was going to get time, but let's get minimal time. And that was literally not based on me, but the way I was trained by my supervisors. We brought good books to court. We brought good processing materials to court. And I extended that to all of my subordinates ever since then. And hopefully some of that information will be useful to you guys if you're not already doing that, which I'm certain most of you are. What I'm going to do, I'm going to turn this over just before the break, but I want to just say this. Once we get to these scenarios in the afternoon, and to be honest, these scenarios will be invaluable to you. And you guys will see when we leave, you'll see how invaluable these are. But what I hope when you navigate through these pages is this. If you've learned anything, there's certainly the possibility that you have not. But if you could apply some of the concepts. In fact, I challenge you this. If you've learned nothing in the last day and an hour, if you could just attempt to see what would be applicable to this scenario based on what you've heard. Just maybe a new way of approaching things. Sometimes we just need to switch the way that we look at the same problem. If you remember yesterday, I mentioned the hammer. Sometimes if that's all you have, that's all you think. And we often think my way must be the best way because it's what I always do. You know, that's a big cop thing. Tradition is hard to shake. And then policing, trust me, I've been involved in it for a little while. But the fact of the matter is, if you apply, this is not an accidental endeavor. We literally gave you an exercise that if you paid attention, and everyone was astute yesterday and very responsive as far as I'm concerned, if you apply the principles that we humbly introduced to you yesterday, then you'll have no problem navigating through this, and it'll be a fruitful exercise for both. This will be, like I said in the very beginning, it'll be a mutually beneficial endeavor, training both ways. We're not doing all the training. We're learning a lot from you guys.
Just in the last few minutes before we take a break and we focus on the case scenarios, when we write up our when we discuss what issues you may be facing as far as case management, what is causing some of the backlogs, we talk about what we can do practically, sooner than later, such as the checklist helping or assisting in report or file preparation and the vetting process before the file goes to the prosecutor. And I'm hoping that those checklists will provide some type of ease sooner than later if you're able to adopt some of the checklists and tailor them towards your country. Is there anything, and I'm including Barbados in this too, is there anything regarding your criminal procedure code that I can write up as a recommendation that would need some attention? Is there something that you might want us to consider asking that it be amended? Is there anything else aside from sometimes the vetting process? Because that's what we're seeing right now. It seems like the vetting process is at this time what's causing some of the delays in moving the case forward. I know that we talk about defense counsel too, and some conflicts that they say they have or are alleged to have with the magistrates courts and high courts. What are some other reasons for case delays that we could make recommendations to or discuss, and maybe additional trainings can be brought to your area? Microphone, please.
Inspector Charles again. One of my concerns is the tardiness of the reports from the doctor. That is really putting us backwards. I can testify in that event because of the number of matters I have coming before the court. And I have to seek adjournment because most of the files, there's no report from a doctor. And there's a long process before you could get a report, and it takes too long. I don't know if that could be fast track, and then that probably will reduce on the amount of backlog we have in the courts. Thank you.
Let me ask a question. While you are waiting for the medical report, do you have the rest of the file?
Yes. We continue, but sometimes it takes too long before we get that report, and I have to be steadily adjourning the matter. Thanks.
On an average, how long does it take for you to receive a medical report? I know depending on what it is, but
it takes long. I had a matter in Granby, it took 11 years. And there are matters that took 5 years. I'm being honest.
Rest of your life. But that is an administrative issue, and maybe as you speak about amendment, it could be probably something we can consider as putting in legislation, whether it be the Evidence Act or not. Now, the issue of delay, and I know I don't know if any of the police officers want to answer the question, but the whole issue of delay, it's a feature of the kind of criminal law that we have, our criminal law. We have an Evidence Act, we have a Criminal Law and Procedures, we have Magistrates Code of Procedure Act and other acts, and most of them are archaic, outdated. Mm-hmm. And really they suited a time that when there was not so many crimes and so many sophisticated crime. The Evidence Act, it's an 18-something act. The Magistrates Code of Procedure is an 1871 act, mm-hmm. and maybe based on older statute. And the Criminal Law and Procedure is older. And a lot of our sister jurisdictions have moved on and amended their law. So I think overall, what we need to do is to amend our criminal law and procedure. We are still laboring under the archaic preliminary inquiry, which is conducted very much like a trial. Yes. Most jurisdictions, even in England, from whom we got the preliminary inquiry, don't even have a preliminary inquiry. They don't even have a paper committal process. Huh? They have dispensed before that. Huh? But we are still laboring under it. Not only is it outdated, It's expensive. It's very expensive. It's a waste of judicial time. It really is what is keeping us from yes, the doctor's report and so a problem, but the system itself lends itself to that because everything takes very long. So that is the kind of recommendation that we need. We know that the criminal justice advisor, she has spoken to us about looking at our legislation and making recommendation. That is Sarah Abraham. So probably if you're in contact with her. But for us, that is really fundamentally necessary. It needs to be done like 10 years ago.
Yeah.
Not just yesterday. And I think that is overall problem. And in doing that, we can take care of some of those other issues that cause this delay. But we're not going to succeed if we maintain the kind of legislation that we have. It really needs revamping.
Is it in addition to that? Because when I did read the criminal code and criminal procedure code, I did wonder when was this written. I had to go back and look at the date.
I haven't read some of the paragraphs. They say all words. We don't even know what they mean.
Would it be helpful, and can it be done that when an investigator's initial report, when it's sent up to be vetted to the first line supervisor, is it possible for a report to also go to the police prosecutor?
What happens is that the investigator writes a report to the commissioner of police about his investigation, just a report, not the statement. He writes a statement. And generally, that report comes on the file for me to see. It's not a document that goes before the court.
Right.
Or to be disclosed or anything.
Exactly.
It's just a document that he sends to his superior, to the commissioner of police. And we are allowed to see it. Because it can be helpful, especially if you're going to write facts when somebody plead guilty, you get a gist. So it's helpful. But what also comes is the witness statements that he has taken, the exhibits he has collected, etc., etc.
So there's never an issue of a prosecutor being in court like during the initial or first appearance and not having something if that person decides to plead guilty.
No, there will never be that problem, because the thing is that generally for summary matters, the prosecutor, the investigator would have prepared facts. The only time you'd have a problem with the facts is if he probably a little tardy or something, but generally you could stand on the matter and get the facts. So there will not be a problem for the facts.
Would training in report writing and identifying elements be helpful for the investigators, the supervisors?
Oh, certainly, because what the prosecutor finds that sometimes the facts is devoid of essential things, because the thing is that even if you're going to give the facts must show the element of the charge that was filed against the defendant. And if it doesn't, then the magistrate might well dismiss the matter, or he might set it for trial. So the facts mustn't be just facts. The facts must be facts that really explains and shows and discusses the element of the offense.
Okay.
So, Madam,
that's
why I asked. That's why I asked earlier about the reporting, and you were talking about reasonable suspicion.
Mm-hmm.
So our checks and balances, you're exactly right, but they're done before I can even bring the human into confinement. Like literally, the elements must be hit. As a matter of fact, that's what I do right now on a daily basis. I check the facts. No one can be put into our holding cell without me hitting the final approval button. There's a desk sergeant that reviews it preliminarily, and then I must, for the 106 persons working each night on my watch, that it absolutely can't make it to court without that. I have a question for you to ponder, because we're going to send you guys on a break, but are some of your crimes associated with human trafficking by any chance? No, not a lot in the region? Okay. I'm sorry? Oh, minimal. Okay, I was just curious because of some of the responses you made.
I'm going to talk to get from Barbados first, and then we'll
Although we have a
question before you go about Barbados.
Yes, Barbados, go ahead.
Hey, remember earlier we had an issue, technical issue, when you were dealing with the advocacy.
Yes.
Now, we want to know if the advocate must be a police officer.
No, the advocate is normally not a police officer. The advocate may be embedded with the police department or with the prosecutor's office.
So we're looking, like probably a psychologist or counselor or anything like that? Social worker?
Yes, the advocate does pretty much have a background in social work, or criminal justice, something along those lines. But again, instead of still having that educational background, they still have to have that personality. They have to be that talent. It's a gift from God. I can't explain it to you when you meet some of these people. It's a position that's created especially for those people. They're able to relate to people from all walks of life.
So you talk about the charm factor. You heard that? Yeah,
Charm factor. Yeah, charm factor. Yeah, it's something about that person that's what they were made to do.
Okay.
Barbados, before we take a break, and again, we have to make recommendations, because if we don't make recommendations, the U.S. Embassy assumes everything's okay.
Yeah.
And, they take their funding elsewhere. So we want to make sure that if there are things that we could recommend, I mean, we brought to you checklists and we talked about victim witness advocacy and advocates. What are some of the reasons for your delays? What type of trainings would you like to see in the future?
For sure, we elect that victims' right bill. You heard that? You elect the victims' right bill to get that.
Victim.
Our laws.
Anything with report writing? I'm almost sure hopefully you'll have additional trial advocacy training, but what are some of the issues that are causing delays? I mean, are the officers identifying the elements? Do they need training in testifying in open court? What are some things that we could recommend that will help you make your life easier?
We are having challenges with the economics with the pretrial disclosure, because some files are very, very thick, and so you have multiple accused. You have to prepare loads and loads of documents to serve on each one, and that is a serious cost factor, especially with photographs, because when you have multiple color photographs, there's a lot of ink and high volume and high cost again.
Okay. I'm sorry, I can't hear you.
No, we're saying the high cost, especially when you have pretrial disclosure, that's our main issue. Our photographs in particular, especially in cases with multiple accused.
Let me ask both countries, and I know it's not on the books, and I'll just give a little spiel real quick before we take a break. They do it in the United States, they do it in England. I wanted to talk to you about plea negotiations or plea bargainings. We use the words interchangeably. We use plea negotiations when we have really strong cases, and we use plea negotiations when our cases may take a turn and there may be some aspects of a matter that are weak, that become weak over time. As part of plea negotiations, you can almost negotiate things, certain aspects of a sentence, such as whether or not we would agree to recommend probation in a case, whether or not we would agree to a certain sentence similar to the good year, whether or not we would agree to a certain sentence. As part of plea negotiations, we might add that restitution be included in a sentence. With plea negotiations, we may add, and which is great for me as a prosecutor, but we add when a defendant pleads pursuant to a plea agreement, there is a waiver of appeal in that plea agreement. So there are only maybe 2 instances where he's able to appeal his sentence, and that would be based on prosecutorial misconduct not known at the defendant at the time he pled guilty, or ineffective assistance of counsel. But he cannot appeal just because he doesn't like what the sentence is. We can agree that a defendant in a case may do community service, may take anger management classes, alcohol classes, things of that nature. So there are different things that we can agree that a person can plead to one charge and that another charge be dismissed. Anything to help save resources, because we want to focus most of our time on the more serious matters. And I say this all to say, and I'll just use this as an example, and I brought this up to my colleague the other day. There was a gentleman, and I know that some people have different courts, but we were in one country and observing an illegal parking trial that lasted an hour because somebody had parked more than 30 minutes in a park. And the defendant had maybe 3 tickets that were on the docket for that day. And so there were other cases that were on that docket. Murder, there was theft, there were assaults. Other cases were just based on the charge. You knew they were more serious than this parking ticket. And so in the back of my mind, the first thing I would have done is ask the defense counsel, will his client plead to 2 and we'll dismiss one of these parking tickets. This is some mess. I don't want to use a bad word, but I don't want to spend time on this. And I don't, and it actually took an hour, and the defense counsel was acting like it was a Perry Mason. I don't know if you know Perry Mason, but it was just like he was Johnny Cochran looking for something in a speeding ticket. I was like, this is ridiculous,
Normally we don't have plea bargain, but what would happen if
microphone?
If defendant said he wants to plead guilty to one of the charges?
Yes.
And especially if it's the higher charge or the charge we have more evidence on.
Yes.
We may take his guilty plea and not offer any evidence in the other 2 matters.
So you do.
But the thing is that usually we don't suggest it. He suggests that when he wants to plead guilty, he will say he wants to plead guilty, and we may take that course of action. Or his counsel may go to the prosecutor and ask, and based on what the evidence is, the prosecutor may agree. If it's something that's a little offensive or high nature, he may discuss it. He'll call it DPP, so we can have a discussion. But we don't have plea bargaining like you do.
Well, it's a sort of plea negotiation, though. It's still a sort of plea negotiation, and the same thing. We do assess the evidence in the cases before we are able to agree or not. It's just that from what I see, the prosecution waits on the defendant to initiate, and then we'll discuss. But we will initiate also, and I will tell you in federal court and in state court, because we have certain sentencing enhancements, we will give disclosure very early. We get disclosures early unless it's some type of really, really serious matter that is going to take some time. But in most cases, disclosures are given to us very early, and we hand over disclosures with a plea agreement, and he pleads to this within 2 weeks, and if he doesn't, then we will enhance him. So that's part of our negotiations too. So that's why it's so important to get those disclosures early and turn them over to defense counsel. And like I said, because plea bargaining is so routine for us, what we offer is the most serious, readily provable matter. we don't offer what's less. We offer the most serious, readily provable matter. And if they don't accept within a certain time frame, then we would say we would enhance this person, and we're going to go forward whatever way. But once the enhancement is filed, we will not remove it. And so it's a lot easier to, is it time? Yeah. Okay, so we can talk about it a little bit more, and then we'll go into our fact patterns, but let's take a 15-minute break.
Okay, gentlemen. That's
Oh, snacks? Oh, okay, thank you. Thank you. You going to?
It's a little cupcake.
All right.
You don't want a cupcake?
And maybe I'll do.
Oh, it is. Oh, okay. Yeah.
Oh,
Is that too much?
They're never, yeah, I know it's not, they're never going to do it. You know how I know? Because even the prosecutors, they don't give the reason is because, and you can ask.
Oh, I know.
They
I
don't
know.
give, because to them, what they can't reconcile is it's not giving. Because here's the problem. They think oh, we're coming out. We're coming out. We're coming out.
Yeah, no worries.
They think it's given.
Oh, I know.
And they're like, no, boys, because there's culture.
Yes, you can just take anything.
I guarantee. Now that's a bet.
No, we know. I know.
It's so crazy though, because they're like this. It's like, oh no.
Okay, so
It's like that's a line in the sand. No, some of the other things they're bendable on.
Yes.
Like they love the advocate part.
Friday,
But because they're like, and I love that they love
The
that.
thing is, for me, I was like, you'd rather sit here and try this case.
Oh, you know I agree. I
I'm
love
sorry.
But, so I have to go to office to check on something. I thought my flight was no. I thought my flight. The thing is that she's asking about training, huh? But the thing is that I mean, and we have this report, but I think training.
Dominica, I'm muting your mic over the break.
Understood. Thank you, sir.
No problem.